right, we're back with part 1B of civil rights. Hang on just. Okay, sorry. Okay, let's get started here. Okay, sorry. My wife is sick, so those were two texts that I needed to read. Okay, so let's continue on here, and we start with some history now. Race is really what we're looking at here when we talk about discrimination and civil rights. So that's where we start. Of course, we start back in the slavery era, just prior to the Civil War is where we'll pick this up. And if you remember, hopefully from last year, the case, perhaps the worst decided case in the history of the U.S. Supreme Court, the Dred Scott case. And if you remember, just the results of that case was that slaves were property. They had no rights under the Constitution, and Congress could not ban slavery in the Western Territories, which of course blew up the Compromise of 1850, which prior to that also blew up the Compromise of 1820. So that's where we sit as we get to the Civil War. Towards the end of the Civil War, we get the 13th Amendment, which is going to be on the right side there. So obviously you don't have to write that down, but it is the one that outlaws or bans slavery as unconstitutional. So that ends slavery, and it's the first of what we call the Civil War amendments. 13, 14, and 15. We've already talked a little bit about 14. 14 has a lot of other stuff in it. And then 15, perhaps if you remember, that at least gave black males the right to vote. So on from there, then we get to the Reconstruction era, where things started to change a little bit. But once Reconstruction ended in 1876, if you remember, I hope, then things just started in the South to go back the other way. We actually call it the resegregation era when we're talking about this particular subject. That's when the Jim Crow laws begin in the South, and all of those laws that regulated separation of the races in public facilities. And that's really where we're getting to the civil rights portion here. Again, we have another court case that you just have to know the result of it and what it did. Hopefully you remember this from last year as well. The Plessy case, where they decided perhaps the second worst decision in Supreme Court history, ruled that separate but equal was constitutional. This one involved railroad cars in Louisiana, separate segregated railroad cars. So it ruled that separate but equal was constitutional. And that's going to last well into the 1950s, where we'll eventually get to our case here that starts to overturn all of this. But we have to get there first. So we get to the civil rights era, right? The 1950s and the 1960s, more often than anything else. But it takes the NAACP almost 30 years to start working through these cases. And so they begin in the late 20s, early 30s to establish judicial precedents. And remember, it's the precedents that work through the system. And they were extremely intelligent in how to do this. They knew it was going to take a lot of time, but they put in the time and they put in the effort, and they managed to do this, to set those precedents to start to overturn and finally get to the point where you could overturn separate but equal, especially in education. And they started to be successful in the late 30s and early 40s and into the 40s with higher level schools, where they would, meaning colleges, right? Colleges and even graduate courses. And one of the things that they were very successful with, and they were very smart about it, is they would do things like they would start with law schools, segregated law schools, because they knew that the justices and the judges in the entire system are lawyers, and they would understand the idea that a separate school would not be equal, because they understand that some law schools are better than others. And so they would say, the University of Texas Law School was great, but what they set up that they said was separate but equal, well, a school in a basement somewhere with one professor for the black students, that was not equal. They knew that. So they were able to use the judges and the justices' own backgrounds to help them understand and get to the point where we're going to get to the Brown decision. And eventually, getting to that, they found a set of cases to try to take to the Supreme Court to overturn that whole doctrine in public schools. So we're talking about primary and secondary schools, so elementary and high schools. And what they're going to do is force the court to decide if separate but equal violated the Equal Protection Clause. And that's what their clear goal was. Okay? So that gets to the case. And it's actually two cases that we're going to talk about that kind of go together, called Brown and Brown 2. So we start with Brown versus Board of Education. So it's Linda Brown. It was really 5 cases in one, but this was sort of the lead case, so this is where it gets its name. And the Board of Education there is the Board of Education of Topeka, Kansas. And this is going to, and so this is our case, so we're just going to do a quick summary here. You'll do the assignment, we'll get more detail. Overturn the Plessy decision regarding school segregation, called it inherently unconstitutional. Separate but equal, inherently unconstitutional. And then Brown 2, the next year, they had to order, because it wasn't being implemented, so the NAACP went back and said, hey, Supreme Court, tell them to implement this, please. And so they did. So they ordered desegregation with the words they used in the decision, and you'll see it, with all deliberate speed. The problem is that the southern states chose to read that all deliberate speed. They chose to read a different definition, and there's a different definition to deliberate, which could mean slow and steady and deliberate. So they chose to read it that way, and they said, okay, that means we can go slow. And that term became what was called massive resistance, and the South said that right out loud. We are going to resist this, and we're going to call it massive resistance to the Supreme Court decision. And you're going to have to make us do it, and eventually they will, right? So let's talk about a couple of things here. Events that happened in 1957. The president at the time, Eisenhower, had to send National Guard soldiers to make sure Little Rock Central High was desegregated. There they are protecting the first black students. I think they're called the Little Rock Nine, if I recall. The first black students to register and enter and take part in high school in Arkansas. Same sort of thing happened at the University of Alabama, where prior to the intervention of the federal government, the governor of Alabama, then a guy named George Wallace, who will run for president later in 1968, he will actually what they call stand in the schoolhouse door and stand there and prevent until the National Guard, in that case, got involved as well. And again, so we start with, and here's where it really started to happen. In 1964, the Civil Rights Act of 64, which we'll talk about later in this part of the unit as well, on the next couple of days, this is where it started to happen. Once they passed this thing and they prohibited federal aid to schools that were segregated, federal aid was used by all schools just like it is now. In fact, probably even more so now. Here at Lambert, we get federal aid, but we have to follow rules. And one of the rules is that schools can't be segregated. So this is where it started to happen, because this is where you say the rubber meets the road, the money. It was money. They saw now the southern schools went, holy cow, we are going to lose federal money, which we need. So basically you could say that's what caused desegregation in the end. It was at hand. Once they threatened them with money, that's what did it. So it took a while to get from Brown in 54 to really meaningful desegregation throughout the South by the time we get into the 60s. All right, so segregation, we'll talk a little bit more about that because we have some different ideas now. De jure segregation, this means by law. That is segregation by law, and that is unconstitutional. That is outlawed. It's outlawed by Brown versus Board in education. It's outlawed in various other cases in various other parts of public life, public accommodations, things like that. So what about other types? There is another type, and it's called de facto. So if de jure is by law, de facto is segregation in fact, segregation in reality. And that happens, even happened after the Brown decision, because it's where people live, where people choose to live. And so you get the idea, we'll use schools here, right? Are we assigned to schools by the area that we live in? And we are, right? Yes, Lambert has an attendance zone, and South has an attendance zone, and whatever it is. And that can be de facto segregation. Nobody's doing it on purpose. It's not by law. It's just happened. Neighborhoods are segregated. People tend to live in places that with other people they're comfortable with. It's just what happens. There are this neighborhood and there's that neighborhood, and there's this county and there's that county, and there's this city and there's that suburb, and all of that. And it's something that is in existence, but it's not by law. It's just something that we have to understand. That there is some segregation in reality, not based on any government action or anything like that. And so maybe the idea is, and some people think there is an idea, are those different than white or black only schools? Things like that. And certainly when this stuff first started, back in the 50s and 60s, there was going to be a significant difference, and at least to the last slide for today. Solutions. One of the solutions that was come up with in the 60s and the 70s was something called busing. Let's fix this by forcing segregation in places where there was de facto, not de jure, right? De facto segregation. So let's force desegregation by busing. And some courts ruled, and some other places did, that to overcome, and so some of these were court orders, to overcome past discrimination, you are going to have to bus students out of their neighborhoods. And so you're going to have to take some, like you could just say half the black students from this inner city school, bus them out to the suburbs, take half of those students from that suburban school and bus them into the city, and now you have desegregation. You have a racial balance. That did not go over well. And that did not go over well in all quarters. So busing white students to predominantly black schools and vice versa. And not surprising, it didn't go over well with the white students and their parents, but it also didn't go over well with the black students and their parents. Nobody really liked this except government, okay, or the courts. Because a lot of times that meant, okay, so you're going to go to a different school, so you send black students from an inner city school, but which might be a less quality school, and send them to a more quality school out in the suburbs, but they're going to have to ride the bus for an hour and a half a day going there, and an hour and a half a day coming back. And parents didn't want their kids that far away from them, and all of that kind of thing. Busing did not go over well. It is very much something that is not used much at all today, if at all today. And it's not just in the South. The northern schools did this. There were riots in various places. And I think, if I recall correctly, one of the worst places for riots, this gives you an idea, it came from all over the country, was in Boston, a place that wouldn't be noted for slavery, obviously, and things like that. They weren't there. They didn't have a legacy of all of this discrimination that happened in the South, but yet still, even in places that they would have considered themselves enlightened and all of that stuff, they still had problems with it. This was just a problem overall. So again, much less prominent today, again, because nobody likes it. But it was something that happened, and it's part of our history, especially in the 60s and 70s. Okay, so that's it for today. You got two halves of this, and you got a case as an assignment. Brown versus Board is your assignment, and we will pick up again on Thursday. So I'll see you then.